Good afternoon, everyone, and welcome to the University of Minnesota. What a special honor it is to have U.S. Supreme Court Justice Ruth Bader Ginsburg with us today and to be joined by Vice President Mondale. Thank you so much for being here.
There's Vice President Mondale in the third row.
It's also our privilege to have here today many distinguished members of the state and federal judiciary, including the Chief Justice of the Minnesota Supreme Court, Lori Gilday, and Associate Justices Wilhelmina Wright and David Strauss. The Chief Judge of Minnesota's Court of Appeals, Edward Clary. The Chief Judge of Minnesota's U.S. District Court, Michael Davis. And many other distinguished members of our state and federal judiciary. And 3 members of our Board of Regents are here this afternoon, Chair Rick Beeson and Regents Tom Devine and Peggy Lucas. And we welcome them all. Justice Ginsburg, our mission at the university is succinct and one that I believe mirrors your personal and judicial sensibilities. We were founded in the belief that all people are enriched by understanding. We are dedicated to the advancement of learning and the search for truth, and we share our knowledge for a diverse community. And we seek to apply this knowledge to benefit the people of the state, the nation, and the world. At our core, then, we are fundamentally committed to a just, equitable, and fair society. Our mission and your undaunted work for justice, particularly for women in the workplace, feel deeply connected. Your perseverance and success in the face of discrimination against women in the legal profession is an inspiration. After all, I understand you were one of only 9 women in your law school class of 500, and I've been told that you were actually scolded for taking the place of a qualified man. Thank goodness for that. As only the second woman to sit on the United States Supreme Court, you've continued to show extraordinary courage, wisdom, and leadership in your opinions, and to serve as a truly historic role model. Amid a changing legal and political climate, your courage is unmatched. Now, I'm an engineer and I like numbers. This room seats about 1,000 people. When word got out that the justice was coming, students and faculty gobbled up the first 550 tickets. The remaining 450 tickets went online at 10 a.m. in the morning and were gone in 17 minutes. Clearly, the entire community wanted to be here today to see you and listen to your thoughts. So on behalf of the entire University of Minnesota community, I thank you for honoring us with your visit, and I welcome you. It is now my pleasure to introduce the leader of our University of Minnesota Law School, Dean David Whitman.
Well, good afternoon. Thank you, President Kaler. It's my great pleasure and privilege to welcome all of you to this afternoon's conversation between the law school's Everett Fraser Professor of Law, Robert Stein, and Supreme Court Justice Ruth Bader Ginsburg. Before I introduce our speakers, let me take care of a little housekeeping. If you have a cell phone with you, which you don't because you're not supposed to, but if you do, please take a moment and turn it off. When the conversation between Professor Stein and Justice Ginsburg concludes, there will be some time for questions from the audience. Those wishing to ask questions at that time will be able to step up to one of the microphones that will be available in the aisles. The conversation and the Q&A that follows will be recorded and posted on the law school's website. It may also be rebroadcast in whole or in part by some of the media, so you may wish to bear that in mind if you choose to ask a question. The Stein Lecture Series, of which today's conversation is a part, was funded through the generosity of Bob and Sandy Stein and also Kevin Yi Chin. Kevin and Sandy are in the audience this afternoon, and Bob is about 15 feet to my left. My thanks and appreciation to each of them. Most of you already know our speakers well by reputation, if not in person. Professor Stein is a graduate of the University of Minnesota Law School. He finished with what may be the highest GPA of any student ever to attend this school. For the students here who are justly proud of their 4.0, consider this: Professor Stein had a 16. Of course, the law school operated on a different scale then. But even so, it was an extraordinary academic record. And this year marks the 50th year since Professor Stein joined the law school faculty. It's been an amazing 50 years. He has been tirelessly teaching, publishing, and engaging in community service at the highest levels. He's one of the country's leading authorities on trusts and estates, and more recently on promoting the rule of law. Over the years, he has served as Dean of the Law School, Vice President of the University, Executive Director of the American Bar Association, and Commissioner from Minnesota to the Uniform Law Commission. This will not be his first conversation with Justice Ginsburg. Indeed, they've known each other for some 40 years, but not to worry, they still have plenty to talk about. We are, of course, deeply fortunate and honored to have Justice Ginsburg as our special guest this afternoon. She has long been famous in legal circles. She is now famous in popular culture as well. At the Minnesota State Fair this year, the only things going faster than Sweet Martha's cookies were the notorious RBG buttons. She even has her own Tumblr page, which explains the connection to the other notorious this way. They were both born in Brooklyn. Both have extensive experience with the law. Both are considered among the best in their field, and both are known for telling it like it is. Justice Ginsburg achieved her celebrity the old-fashioned way. She earned it. After graduating from Cornell, she attended Harvard Law School and then Columbia Law School. I have to say, this part of the introduction would have gone even better if she'd managed to attend the University of Minnesota Law School as well. But it's all good. She's here now. Of course, she excelled at both Harvard and Columbia. She graduated at the top of her Columbia class. She then taught at Rutgers and Columbia Law School, where she became the first tenured woman and co-authored the first casebook on sex discrimination. She also co-founded the Women's Rights Project at the ACLU and became the ACLU's general counsel. In that capacity, she briefed and argued a series of landmark cases before the very court on which she now sits. She was appointed to the U.S. Court of Appeals for the District of Columbia in 1980 and to the U.S. Supreme Court in 1993. Of course, simply reciting the bare facts of her career does not do it justice. Over the years, she has placed an indelible stamp on U.S. law and constitutional jurisprudence, and she is a hero to those who care about justice, equality, and the rule of law. So it's particularly fitting that she should speak here today, September 16th, because today is, as I'm sure you know, National Heroes Day. Well, it is in St. Kitts and Nevis anyway. September 16th is also a fitting day for our conversation for another reason. Today is Professor Stein's birthday. Please join me in welcoming Professor Bob Stein and Supreme Court Justice Ruth Bader Ginsburg.
Well, thank you, President Kaler, for your welcome, and thank you, Dean Whitman, for your very kind introduction. Good afternoon, Justice Ginsburg.
Happy birthday.
Welcome back to the University of Minnesota. I think the last time you were here, you were our commencement speaker for commencement.
During a heat wave, the students didn't bank on because they were wearing cap and gowns. It was sweltering, so I knew immediately I had to cut 10 minutes out of my speech.
Well, it was a wonderful speech, even without the 10 minutes. But you've continued to be very generous to this law school. You've published articles in our Law Review, and in fact, this conversation will be published in the Minnesota Law Review. And you continually, regularly send me speeches that you give about the rule of law. You care very much about human rights and the rule of law, and send these works to be added to teaching materials for the class. So thank you for your generosity. So let's begin the conversation. You know, you have a really important job. You know that as a Supreme Court Justice. It's really prestigious. But I've heard you say it's not your dream job. What would be your dream job?
If I had any talent God could give me, I would be a great diva. I would be Renata Tebaldi, Beverly Sills, Marilyn Horn. But in grade school, the music teacher ranked me as a sparrow, not a robin. So I was told to mouth the words. So I sing in only two places. One is the shower, and the other, my dreams.
Okay. Well, I think being a justice is probably a close second. Isn't that a fair statement?
It is the best and the hardest job I've ever had.
Indeed. Now, you love opera. Let's talk about that for just a minute. What are some of your favorite operas? I know you care very much about opera.
That's a question like asking me which of my grandchildren is my favorite. And I love all operas, but most of all Mozart. And one day I will tell you Don Giovanni is my favorite, and the next day The Marriage of Figaro. And I love Verdi, Puccini, Rossini, Bellini, and modern operas.
Also.
This year in D.C. they had a stunning production of Moby Dick by Jake Heggie, the same composer who did Dead Man Walking.
Okay.
And this summer at the Glimmerglass Festival in Cooperstown, New York, I attended a performance of An American Tragedy based on the Theodore Dreiser book by Tobias Picker, another fine U.S. composer.
A wide area of interest.
And my next opera outside D.C. will be at the Met to see The Death of Klinghoffer.
Oh, all right. Well, I'm going to come back to an opera, unusual opera, in just a minute, but let me just, your son shares your great love of music, your son Jim. Do you want to mention what he does?
Yeah. James runs an organization called Sadie Chicago. It makes exquisite compact discs. The idea is to feature great artists from the Chicago area who have not quite made it to the top, but to give them a boost that will get them there. Now, this career choice for James, it started when he was very young. James was what his teachers called, I called him lively, they called him hyperactive. But when I took him to concerts, even when he was very small, he was rapt attention. So I knew he had a passion for music. Then I made a bad mistake. His piano teacher was a woman named Miss Cherney, and she was a descendant of Carl Cherney, the Cherney exercises. James grew up with a mother, a big sister, a housekeeper. It was really too many women. And I was, and am to this day, an ardent feminist, but I called the Juilliard School and said, do you have a young man who teaches piano? And it worked like a charm. And James had no other word for it, but a passion for music. The artists he records love him because he turns out truly exquisite CDs.
I know you're very proud of them, and I wanted to have you have a chance to talk about that. And your daughter is a law professor at Columbia, but she has a music connection, doesn't she, in her work?
Jane is the Morton L. Jacklow Professor of Literary and Artistic Property Law at Columbia Law School. Mm-hmm. She is a world-respected copyright expert. And your husband, Marty, who sadly passed away recently, I don't know if Marty was a great music lover, but I know he was a great cook. And I thought it'd be interesting to the audience for you to share with them what the spouses of the justices have done to honor Marty Ginsburg. When Marty died, the spouses who lunched together quarterly came up with the idea that the greatest tribute to him would be a cookbook. So the book is called Supreme Chef. It is the best-selling book in the Supreme Court's gift shop. And each section is introduced by a different spouse, and the spouse recites her memories of Marty, and so it starts with Maureen Scalia. This was the idea of Martha Ann Alito, who also loves food and is a very good cook. And Marty had about 150 recipes on a disc, and Martha Ann picked 30. I showed it to my daughter, who learned from an expert and is a very good cook herself. And she said, "Mother, those are not the recipes Daddy would have picked." I said, "Jane, you choose which ones will go in." And in this cookbook, there's one under appetizers, a recipe for Jane's Caesar salad. Okay. So she got herself into the book. But we'll start moving towards law, but one more question along this line. When I visited with you in your chambers a couple of months ago and said, "Are there any questions you wanted me to ask or any questions you didn't want me to ask?" you said, "Ask me anything." But then you said, "Ask about Scalia-Ginsburg." What is Scalia-Ginsburg? It is a comic opera. And it came about this way. A very talented musician, Derek Wang, had a music degree from Harvard and an advanced degree from Yale, and then decided that he would be good to know a little bit about the law. So he's from Baltimore. He enrolled in the University of Maryland Law School. In his constitutional law class, he was reading these opinions, dueling opinions by Scalia and Ginsburg, and decided that this could make a very funny opera, but also with a serious underlying theme. Shall I give the audience some samples? Maybe you could give just a little, well, why don't you take the theme? We need to get to the other questions, but there is a very funny theme. Why don't you cover that? Well, it opens with Scalia's rage aria, so it's modeled on Handel, and Justice Scalia sings, "The justices are blind. How can they possibly spout this? The Constitution says absolutely nothing about this." And then I answer, telling him he is searching for a bright line solutions to problems that don't have easy answers, but the great thing about our Constitution is that, like our society, it can evolve.
Evolve.
There's a beautiful duet at the end, and I left out the central scene. Justice Scalia is confined to a dark room for excessive dissenting. And I come to rescue him, but I enter the scene through a glass ceiling. The final duet is, we are different, we are one. Different in our views on constitutional interpretation, but one in our reverence for the federal judiciary, for the institution that employs us, our reverence for the constitutional system that we have.
Well, I think we should all look forward to seeing that. It is going to be performed, I think.
It is likely to have its opening fully staged performance in Castleton, Virginia next June.
Next June. Well, now, you and Justice Scalia share a love for opera, but you also have a very strong friendship. And Justice Scalia has a different judicial philosophy than you do, and yet you each have this friendship for each other. Can you talk a little bit about collegiality on the court?
It is the most collegial place I've ever worked. Beyond any law faculty, beyond the Court of Appeals for the D.C. Circuit. We're very much like family, and we have some customs that remind us of our mission and that help keep us together, and that is every time that we confer, and before we go on the bench for argument, we go around the room, each justice shaking hands with every other. For the mathematically inclined, that amounts to 36 handshakes. And the idea is you look at your colleague as if to say, yes, you circulated a nasty dissent yesterday, but we are all in this together. We revere the court, and we want to make sure that none of us do it any harm. Then there's lots of togetherness. You know, we go different places in the world together. Yeah. There's a famous photograph of Justice Scalia and me on a very elegant elephant in Jaipur, India. Last September, 4 of us went to Ottawa to have an exchange with the Supreme Court of Canada. Last winter, 4 of us went to Luxembourg. It's the seat of the highest court for the European Union, the European Court of Justice. And then we celebrate birthdays. So if you were at the court today, the chief would have purchased some wine, and we would have toasted you for your birthday.
Well, I'm glad you and I are here, as nice as that would be, Justice Ginsburg. Now let me ask you, do relationships ever get strained after a particularly divided decision? What about after Bush versus Gore, where the country was strongly divided about the outcome of that, and you and 3 other dissenters wrote some very strong dissents in the case. What was the relationship between the justices right after that case?
At first, we were all exhausted because the court agreed to take the case on a Saturday. Briefs were filed on Sunday. Oral argument was Monday, and the decisions were out Tuesday evening. Things were, I might say, tense. But I told my law clerks, go to Justice Kennedy's chambers and watch on the television what the press is reporting. I chose Justice Kennedy because he was on the other side. I was in my chambers. It was quite late when Justice Scalia called. He was also on the other side. And he said, Ruth, what are you doing still at the court? You should go home and take a hot bath. Well, as I said, things were tense, but the January sitting was fast upon us. And we knew we had to work together on that upcoming sitting. So if there was tension, it was short-lived. Because it was never, you said like Bush v. Gore, there's never been anything like it before or since. The court has never, from the day of that decision, ever cited it as precedent in any other case. And I think it will remain that way.
You said an interesting thing to me earlier today where you said everything was happening so fast that it was necessary to write opinions and get the case out, but I think you said the dissenters might have been able to join in one dissent had there been more time. Could you expand on that a little bit?
We made an effort not to foist too many opinions on the public. We couldn't do it in Bush v. Gore because the time was so short. But if we had a few days more, there would have been one dissent instead of 4, and the press would not have been confused as they were, thinking that Justices Souter and Breyer were part of the majority. They were not.
When Chief Justice Roberts was appointed, one of the things he said is that he wanted to develop greater consensus among the justices. And the last term of the court that ended in June was quite remarkable in that 60% of your opinions were unanimous opinions. The greatest percentage of unanimous opinions, one commentator said, since 1953. So that's over 50 years, if that's correct. And only 14% of your decisions were by a 5-4 vote. And in the immediate preceding year, twice as many cases were decided by 5-4. So can you talk a little bit about this greater degree of unanimity? Were the cases less controversial last year? Were the decisions achieved by finding a narrower ground for decision? What was going on in the last term?
It's true that there were fewer 5-4 decisions. There were 10. But the 60% agreement figure is somewhat deceptive. That represents decisions in which we all agreed on the bottom line. But some of those decisions, in some of those decisions, the court was deeply divided on how you got to that bottom line. So, for example, in the recess appointment case,
NLRB versus Noel Canning.
There were 3 questions. The first question, is a recess appointment permissible when the Congress breaks within a session, an intra, as opposed to an inter-session recess? That was the first question. The next question, if the vacancy exists at the time the recess appointment is made, can the president constitutionally make the appointment, or must the vacancy occur within the recess itself? And then the third question, if the Senate is meeting pro forma every 3 days, can that count as a recess? The first two questions, I think, were by far the more important. Does an intra-session recess count? And can the vacancy exist before the recess? Those questions sharply divided the court, and it was only in the last question, does this every 3 days, a pro forma session, does that count? On that, we all agreed that we had deferred to Congress, to the House and Senate, when it's making rules about how it will operate internally. So we all agreed that the Senate could have the rule about meeting pro forma, and therefore, because the President made the appointments while the Senate was meeting every 3 days, and in theory could have conducted business, the President's appointments to the NLRB were invalid. But the disagreement on the first two questions was so strong that Justice Scalia did something most unusual. Usually when decisions of the court are announced, only the majority opinion is summarized, and then the author of the majority opinion will say, and so filed a dissenting opinion. If one really cares about the dissent, really wants the public to know that there is a different view out there, the dissenter will summarize the dissent from the bench, as I did in the Hobby Lobby case and a few others. There may be one or two of those a year, but never have I heard a concurring opinion summarized from the bench. But that's what was done.
He was announcing his own view on those first two questions that you...
Yes.
Let's turn to something I know many of the audience are very interested in having us talk about. You've been such a source of inspiration and pride for many, especially women, because of your work and scholarship advancing the constitutional principle against gender-based discrimination. During the years you were a leading attorney advocate for the Women's Rights Project of the ACLU, and then during the last 21 years on the Supreme Court. Several of your cases when you were arguing before, how many times did you argue before the court? Do you
Six times.
6 times.
I petitioned for a review many more times than that, but 6 times.
Well, many of your cases are landmark cases in terms of the development of constitutional rights for women in this country. Can you talk about one or two of those of which you're particularly proud and the experience you had as an advocate for women's rights?
Bob, maybe as a preface, I should tell the people in the audience what the world was like before that. The Equal Protection Clause says no state shall deny any person the equal protection of the laws. So that's in 1868. A woman named Virginia Minor said, "Isn't this grand? I am a person. I am entitled to the equal protection of the laws. Therefore, I should have the right to exercise the fundamental right and obligation of a citizen. I should be allowed to vote." And the court answered in that case, "Of course you are a person. We understand that. But so too are children. And no one would suggest that children should have the right to vote." So the Supreme Court, it never saw a differential based on gender in the law as impermissible. The notion was that all of the differentials operated benignly in women's favor. So let's take a case from Earl Warren's time. There was a woman, Gwendolyn Hoyt, who was charged with the murder of her abusive, philandering husband. It came about this way. They had had a fight. He had humiliated her to the breaking point. She spied her son's broken baseball bat in the corner of the room, and with all her might took it, hit him over the head. He fell against the stone floor, and that was the end of their fight, and it was the beginning of the murder prosecution. She lived in Hillsborough County, Florida, and Florida didn't put women on the jury rolls. So Gwendolyn Hoyt, this is her thinking. If there were women on the jury, they might better understand my state of mind. And while they might not acquit me, perhaps they would convict me of the lesser offense of manslaughter and not murder. Well, she was convicted by an all-male jury of murder. The Supreme Court agreed to review the case, and the decision went something like this. We don't understand what this woman is complaining about. Women have the best of both worlds. If they go into the clerk's office and add their names to the list, they will be there. But if they don't want to serve, they don't have to. Then you can imagine how many men, if they had the option not to serve on juries, would go to the clerk's office and sign up. So Gwendolyn Hoyt must have been nonplussed by the court's thinking. The basic point that the court couldn't understand in 1961 was that if you are a citizen, you have obligations as well as rights. And one of those obligations is to participate in the administration of justice by serving on a jury. That's where the court was in 1961 when the, quote, liberal Earl Warren was the Chief Justice. 10 years later, Berger, who's known as a, quote, conservative, is on the court when in a succession of decisions, it struck down one law after another, state or federal, for discriminating impermissibly on the basis of gender. And you asked for examples, so I'll start with what was the turning point case.
Let me take just one, because I want to get to the Supreme Court before too long. Okay. You want to start with, which would be the turning point, Reed?
Reed was the turning point case.
Why don't you talk about Reed?
Sally Reed was a woman who made her living by taking care of elderly or infirm people in her home. She was not, well, she probably didn't even know what the word feminist meant. She had a son. She and her husband divorced, and when the son was of, quote, tender years, she was given custody. When the boy reached his teens, the father applied to the family court and said, now the boy needs to be prepared to live in a man's world, so I should be his custodian. Now, Sally thought that was a dreadful mistake, and she turned out to be right. The boy was very depressed, and one day he took out one of his father's many guns, and he committed suicide. So Sally wanted to be appointed administrator of his estate, not for any economic reasons. There was a small bank account, there was a guitar, a record collection, and that was about it. Her former husband applied to be administrator a couple of weeks later, so Sally was first in time and thought she would get the appointment. The probate court said, Sally, I'm really sorry, but the Idaho Code says, as between persons equally entitled to administer a decedent's estate, males must be preferred to females. Now, the remarkable thing about this case is that Sally Reed, on her own dime, took this case through 3 levels of courts in the state of Idaho. And when the Idaho Supreme Court upheld the law, one of my colleagues at the ACLU said, this is the case that will wake them up. This will be the turning point case. And a unanimous Burger Court held Idaho's male preference law unconstitutional. What Sally Reed's case said to me is, here is an everyday woman. She thinks that she has suffered a wrong, and she has enough faith in our judicial system to think that that wrong can be righted.
Well, this is Ruth Bader Ginsburg, attorney advocate before the Supreme Court in a case holding the Equal Protection Clause applies to women.
And men, because
men.
I think we should describe Stephen Weisenfeld's case. It was a few years after Sally Reed's case. Stephen's wife was a math teacher in a public school. She became pregnant, very healthy pregnancy. She was teaching into the 9th month. She goes to the hospital to deliver, and the doctor comes out and tells Stephen, you have a healthy baby boy, but your wife died of an embolism. Stephen vowed that he would not work full-time until his child was going to school full-time. There were Social Security benefits, he heard, for the sole surviving parent of a child under the age of 12. So he applied for those benefits. The Social Security office employee said, I'm sorry, Stephen. These are mother's benefits. They are not available to fathers. Stephen wrote a letter to the editor, to his local newspaper in Edison, New Jersey. It was to this effect: I've heard so much about women's lib. Let me tell you my story. And the tagline was, tell that to Gloria Steinem. So it happened that someone on the Rutgers faculty, on the Romance language faculty, lived in the same town, saw the letter, called me and said, that isn't right, is it? I said, suggest to Mr. Weisenfeld that he get in touch with the New Jersey affiliate of the ACLU. The court was unanimous in saying that those benefits had to be available for caring fathers, just as they are to caring mothers, but split 3 ways in the reasoning. The majority, in an opinion by Justice Brennan, said, of course, we understand where this discrimination begins. It begins with the woman as wage earner. She pays the same Social Security taxes as the man, but they don't get for her family the same protection. A few of them thought it was discrimination against men because they did not have the opportunity to care personally for their children when they were the sole surviving parent. And one justice, who later became my chief, but he was then Justice Rehnquist, said, this is totally arbitrary from the point of view of the baby. Why should the baby have the opportunity for care, personal care, of a parent if the parent is female, but not if the parent is male? So that case was an illustration of how these gender lines in the law are bad for everyone. Bad for women, bad for men, and bad for children.
Well, let me move us to the Supreme Court. I do want to talk about some of the landmark cases that you have been involved with, and the one that comes first to mind is the Virginia Military Institute case, the VMI case, in 1996. It came on, you'd only been on the court about 3 years at that point, and you wrote the majority opinion in a 7-to-1 decision in which you said the long-standing male-only admission policy of Virginia Military Institute violated the Equal Protection Clause of the Constitution, and you wrote that a proposed parallel program for women to be called the Virginia Women's Institute for Leadership at Mary Baldwin College would not provide women with the same type of rigorous military training, facilities, courses, and so forth. And so this is one of the landmark cases in Supreme Court history on gender discrimination. Can you talk a little bit about that landmark case and how you, relatively new member of the court, led the court to that decision?
Seniority really counts at the court. And the most senior person, the one most likely to be assigned the opinion, was Justice O'Connor. But Justice O'Connor thought that I should write the opinion, and that's how that came about. There were many people who said to me, why would you want young women to go to that military academy? And I said, well, I wouldn't want to go there. My daughter wouldn't want to go there. You probably would not want to go there, though you're male. But there are some women who do want to go there and are qualified, can pass all of the tests. And that was, the whole point was that the state shouldn't create artificial barriers to people who are ready, willing, and able to take advantage of an opportunity. Yeah. I must say the faculty at VMI were very much on the side of change because they saw it as a way to upgrade their applicant pool.
Let's talk about the Lilly Ledbetter case. This was a 2007 opinion where the majority held that the employers can't be sued under Title VII of the Civil Rights Act of 1964 over gender pay discrimination if the claims are based on decisions the employers made more than 6 months before the complaint was brought. And you wrote a very strong dissent. I think that's one of the cases where you read your dissent from the
summary. I didn't read all 30 pages.
Read the summary, right? But why did you dissent? And then, interestingly, this became an issue in the presidential campaign in 2008. There was an act introduced in Congress, the Lilly Ledbetter Back Pay Act. And Congress eventually passed the Lilly Ledbetter Back Pay Act.
Fair Pay
Act. So, one, talk a little about the case, and did you derive some special satisfaction about Congress interpreting the law the way you did in your opinion?
Let's give some background. So Title VII prohibits discrimination on the basis of race, religion, national origin, and sex. It also requires a complainant to file her complaint with the Equal Employment Opportunity Commission within 100 days of the discriminatory incident. Now I'll go to Lilly Ledbetter. She is working as an area manager in a Goodyear tire plant. She is the first woman ever to have held such a job. This is in the late 1970s. Lilly wasn't told what the male area managers, what their salary was. But one day, after she'd been working there a dozen or so years, she finds a slip in her mailbox with a series of numbers. The numbers were the pay of every other area manager, with Lily on the very bottom, earning less than the newest man on the job that she had trained. So she got up her courage and she brought a Title VII lawsuit. The argument that the court accepted, the argument made by the Goodyear Tire Company is, she's much too late. She was supposed to sue within 180 days. From Lily's point of view, when a woman is in a job that up till then has been done only by men, she doesn't want to be seen as a troublemaker. She doesn't want to rock the boat. And besides, suppose she had sued very early on. We know what the defense would have been. The defense would have been, it has nothing to do with Lily being a woman. She just doesn't do the job as well. Then, after she's been working there year after year and getting good performance ratings, that defense that she's not as competent as the men, that vanishes. That's no longer available. So she has a winning case. But the court said she sued too late. Her view was, how could it be too late? Every time I get a paycheck, the discrimination is renewed. So I should have 180 days from any paycheck to begin my case. I thought that that's what Congress meant in Title VII. But if there was any doubt about it, my tagline was, the ball is now in Congress's court to correct the error into which my colleagues have fallen. And with record speed, Congress passed the Lilly Ledbetter Fair Pay Act, large majorities on both sides of the aisle, and it was the first piece of legislation that President Obama signed when he took office.
This time is fleeting so much, I'd like to take it a little more up to date. The last case decided in the last term of the court, on the very last day, was the Hobby Lobby case. And in that case, a 5-4 majority of the court held that a closely held not-for-profit corporation could be exempt from a law that its owners sincerely religiously objected to if there was a less restrictive means of furthering the law's purpose. And in this particular case, Hobby Lobby argued for exemption from the contraceptive mandate in the Affordable Health Care Act that required employers to cover certain contraceptives for their female employees, and the owners said to do so would violate their sincerely held religious beliefs. You wrote a very strong dissent in that case, in which you began with these words: in a decision of startling breadth, the court holds that commercial enterprises, including corporations along with partnerships and sole proprietorships, can opt out of any law, saving only tax laws, they judge incompatible with their sincerely held religious beliefs. And then you went on to say, you warned the majority, the court, I fear, has ventured into a minefield. Why do you feel that the opinion of the majority is of startling breadth? And what is the minefield you're warning your colleagues about?
Until the Hobby Lobby case, it was always understood that if you are engaged in commerce, you must be subject to the rules of everyone else engaged in commerce. I compared the exemption that the government had provided for religious corporations and said that exemption is right and proper because it applies to people of the same faith, people who share the same belief. But a corporation in business for profit employs hundreds, thousands of people who do not share the genuinely held belief of the employer. And it's those people that the law aimed to protect. I borrowed from a great law professor who was explaining the limits on our freedoms. He said, I have a right to swing my arm until it hits the other fellow's nose. So the idea was that an employer in business for profit should not be able to impose the employer's religious belief on a workforce that does not share that belief. And then the minefield was, well, let's see. Some religions reject blood transfusions, some vaccinations, some any medication that comes from any part of a pig. Suppose employers with a genuinely held religious belief against that medical device or practice said, I'm going to leave that out of the health coverage that I provide. Then I took this example from a real case. There is a sect that believes women should be subservient to men, and a woman should not work without her father's permission, or if she's married, her husband's permission. Does that mean there has to be an exemption from Title VII for an employer who holds that belief? Or, to take one more, which was an actual case that I sat on when I was on the U.S. Court of Appeals for the D.C. Circuit. It involved a sect. It was the Ethiopian Zion Coptic Church that had as its sacrament marijuana. But unlike peyote and the Native American church, where the peyote was ingested only at religious ceremonies and in limited amounts, this sect believed that marijuana should be smoked all day, every day. And they wanted the government to respect and accommodate that belief. That's what I meant by the minefield. Yeah.
Only 3 days after the Hobby Lobby case, which was the last case of the term, the Supreme Court issued an unsigned order in a case involving Wheaton College, an evangelical college in Illinois. And in this unsigned order, the court said that pending a full review of the case, Wheaton College, which objected to paying for contraceptives in its health care plan because of its beliefs of the college, did not have to fill out the form that the court in Hobby Lobby had said 3 days earlier was a less restrictive way to recognize an employer's sincerely held religious views, because filling out the form would violate their religious views. Now, the reason I'm bringing this case up is noteworthy in that a dissent was filed to this order by all three women on the court. You were obviously the senior judge in the minority, and you assigned that to Justice Sotomayor, and she wrote a strong dissent in which she said those who are bound by her decisions usually believe they can take us at our word, as in Hobby Lobby, and she went on to say, not so today. Now, I read some commentary about that order that suggested that the male justices just didn't understand the issue, but I want to hear what you have to say. Does that case raise an issue in which the gender of the justices affect the way the justices saw the issue?
We all come to the business of judging with our life experience. Part of my life experience is growing up female. And perhaps there's something to what you suggest, Bob, but as long as we live, we can learn. And my best example of that is my old chief, Chief Justice Rehnquist, who, apart from Stephen Weisenfeld's case, was in dissent from every case in which I prevailed. The Family Medical and Leave Act, very important piece of legislation, was passed. This is a law that's written from the point of view of the woman as worker. What does she need to be able to hold her job? When her child gets sick, she needs leave time. When her husband gets sick, her elderly parent, or the woman herself. That law was argued to be beyond the power of Congress to pass, and Chief Justice Rehnquist upheld it in an opinion that recognized that what Congress had done was something new, focus on the woman as worker, but of course give the same benefits to men who care for a sick wife or elderly parent. The opinion was so strong, so well-reasoned. When I took it home and showed it to my husband, he said, "Ruth, did you write that?" No. and I would say, while you live, you learn. Chief Justice Rehnquist had two granddaughters. We had more than two, but his eldest daughter had two girls. The daughter was divorced, and the chief really cared for those grandchildren. He spent a lot of time with them. There was a tremendous love on both sides. And I think that Chief Justice Rehnquist had learned, thinking about how he would like the world to be for his granddaughters.
The Dean Whitman touched on this in the opening introduction. You've become something of a social media rock star. All of you, after this lecture, should go out and look at the blog, the notorious RB... Templar. Oh my goodness. The notorious RBG, you'll see T-shirts, hoodies, notorious RBGs. I think there's even a rap song, notorious RBG, and then there's another, do I want to say blog or Templar? You can't spell truth without Ruth. How do you feel about this new notoriety that you suddenly have?
My grandchildren love it. And I will confess that when Notorious RBG was first on the internet, my law clerks had to tell me what the Notorious was. But now I know, and I have a supply of Notorious RBG T-shirts. I would have brought one for you if I knew it was your birthday, Bob. But it wasn't the first T-shirt I got was from the National Association of Women Judges. When I was appointed to the court, they had a reception for Justice O'Connor and me. And they gave her a T-shirt that reads, "I'm Sandra, not Ruth," and mine, "I'm Ruth, not Sandra." Because, and they were quite right, because while the two of us sat on the court together, invariably one lawyer or another would call me Justice O'Connor. And they knew there was a woman on the court. For 12 years, she was the lone woman. So a woman's voice, it must be Justice O'Connor, although we don't look alike and we don't speak alike. And then what was the next? Oh, the next T-shirt was in Bush v. Gore. It was my face and then "I dissent" under it. Well, people remarked about that because the tagline is usually "I respectfully dissent," or "with respect I dissent." But I didn't notice that I had never used respectfully dissent. When take an opinion, I won't disclose the names of the author, but the dissenter says in the opinion, "The court's opinion is profoundly misguided," and then respectfully dissents. Or to take another one, "The court's opinion is not to be taken seriously." How can you respectfully dissent? So what I do is, if the lower court is being reversed, I will say, for these reasons, I would affirm the decision of such and such. Such a court, or if the court upholds the decision, and I think it should have been reversed for these reasons, I would reverse the decision. That way I don't have to
worry about
yeah.
Time is fleeting, but I do want to raise a couple of future issues here, if you would comment on it. In the last year, there have been decisions in many state and federal courts on the constitutionality of bans on same-sex marriage. And these decisions have not been all consistent, although the vast majority have struck down the ban. And I think there are now 7 cert petitions pending in the Supreme Court asking the court to take up a case. So I know you can't talk about how you would rule in a future case, but can you comment on the issue generally? Do you think this issue will be coming before the court in the near future? And do you think it's desirable for it to come as soon as possible?
The background is that, not last term, but the term before, the court held the Defense of Marriage Act, a federal law, unconstitutional. At the same time, and paired with it was a case asking the court to hold that California's ban on same-sex marriage was unconstitutional. We didn't decide that case. We returned it on a procedural ground, so that remains an open question. So far, the federal courts of appeals have answered the question the same way, holding unconstitutional the ban on same-sex marriage. There is a case now pending before the Court of Appeals for the Sixth Circuit. Now, if that court should disagree with the others, then there will be some urgency in the court taking the case. But when all of the courts of appeals are in agreement, there's no need for us to rush to step in. So it remains to be seen what the Sixth Circuit will rule, when it will rule. Sooner or later, yes, the question will come to the court. But the remarkable thing is how attitudes in this country have changed on that issue. And I attribute it to gay people ready to stand up and say who they are. When they did that, people looked around, and it was their next-door neighbor of whom they were very fond. It was their child's best friend, even their child. So people began to understand and realize their own prejudices on that matter. I think it's the having people close to us say who they are that made the attitude change in this country.
Let me ask you about another future interest, or at least an issue that periodically has come up. Several justices in recent years, after they have served on the court for many years, offered some comments about capital punishment. And I'm thinking of comments made by Justice Blackmun and also Justice Stevens in an opinion. And again, I don't that you're not in a position to comment on how you would handle a specific case, but having served on the court for these years and having had many capital cases come before the court, can you share your thoughts about capital punishment?
In Justice Stevens' case, it was in a book called Six Amendments. It was published just this year, and Justice Stevens discusses 6 changes he would make in our Constitution. Number 1 is campaign finance. The death penalty chapter is interesting because Justice Stevens was, like Justice Blackmun, was one who had voted to restore the death penalty after there was a hiatus for some years. And he has now come to a different conclusion. Justices Brennan and Marshall, in their later years, said we don't want to participate in this process. We think the death penalty is unconstitutional under any and all circumstances. Well, that means that they couldn't be part of the court discussion. They couldn't influence the result in any case. When I came on the court, this was all new to me because I had been a judge in the District of Columbia that had no death penalty. And I had to make a decision. My decision was I will participate in these cases. I will respect the precedent up to where it is, and I will try to prevent it from going any further. So that's what I have done, and I've said many times, and I think this is true for all of my colleagues, if I were queen, there would be no death penalty. But in our system, that decision has been left so far to the individual states.
We're getting right to the end, but I think we do need to address the fact of your presence on the court and Justice O'Connor's. When you came on the court, you served with Justice O'Connor until her retirement. And then I recall you saying at a time when I was present after she retired, I miss Sandra terribly, I think were your words. And now you have 2 colleagues who are women justices, Justice Sotomayor and Justice Elena Kagan. How, if at all, is the court different with 3 women justices than it was when you were the only woman justice on the court? And if, tag a question on, do you foresee a time when there would be a majority of women justices on the court?
When Sandra left the court and I was the lone woman, altogether the wrong image of the court was projected to the public. There were these 8 men, all of a certain size, and then this tiny little woman. It's not the way it should be. Now, because of my seniority, I sit toward the middle. Justice Kagan on my left, Justice Sotomayor on my right, and we look like we really belong there. We're 1/3 of the court. We're not one-at-a-time curiosities. No one has called me Justice Sotomayor or Justice Kagan. And not this year, but last year, Justice Sotomayor beat Justice Scalia as the justice who asked the most questions at all levels. So they're very lively women, take an active part at argument.
Yeah.
When will there be enough? Well, my answer was when there are 9, and people are astonished. You know, then I remind them that there were 9, they were all men. For all those years, and nobody thought there was anything wrong with that. Our neighbor to the north, Canada, same number of justices, 9. 4 are women, plus their chief justice is a woman. Mm-hmm. So we're moving in the right direction.
Good. Well, I think we should open it up for you to have a chance to ask a question. There are microphones, I believe, in 2. Oh, you have the portable microphones. Someone is in this aisle and someone on that side. If you have a question, would you line up behind the person holding the microphone? We'll try to get in as many as we can in the remaining time that we have. I think there's a question right over there, please.
Justice Ginsburg, now you have an opportunity to be a role model for a lot of people who are considering entering the legal profession. I would consider myself one. When you were considering becoming a lawyer and also a judge, what sort of things influenced you?
What kind of things?
Well, when you were considering becoming a lawyer, what made you think, oh, I should do that? Or
Oh. I was going to college at a bad time for our country. It was the heyday of Senator Joe McCarthy from Wisconsin, who saw a communist in every corner. There was a Red Scare in the country. People were being hauled before the House Un-American Activities Committee, Senate Internal Security Committee, and asked about some organization they belonged to in the 1930s when they were very young. I had a professor for constitutional law who pointed out to me that lawyers were standing up for these people and reminding our Congress that there is a First Amendment and there is a Fifth Amendment, and that we were straying far from basic values. Then it occurred to me, well, the legal profession gives you a great opportunity. You can work and be paid for the work, but you can also do something with your skill that will make things a little better for other people. And that was the idea that law was a profession where you could serve the community that law was intended to serve. That encouraged me to take the law school aptitude test. My family was not pleased about that choice because nobody wanted lady lawyers in those days. There was no Title VII, the discrimination was up front. But then I married the same month I graduated from college, and then my family attitude changed. It was, well, if Ruth wants to be a lawyer, let her try. If she fails, she will have a man to support her.
Well, thank goodness you made that choice. The question up on that aisle.
Thank you. Justice Ginsburg, thank you so much for your tremendous service. I wanted to ask if you could please comment on the Citizens United decision and some of the court's thinking and implications of that.
What I can say about it is read Justice Stevens' dissent. The Bipartisan Campaign Finance Act was passed overwhelmingly by Congress. My notion was that people in the political arena understand better than the justices what money can buy. And I thought that the court should have been restrained, deferential to the political branches that passed that law. I fully expect that someday we will have campaign finance regulation. I hope it will be in my lifetime, but as each year goes by and we see more and more the pernicious effects of huge campaign drives, I think it's the reality that your contribution is going to give you access to a legislator that you wouldn't have without it. And bear in mind that the legislator that you contribute to today is going to run 2 years later and look to you again. So maybe in between, that legislator will be interested in hearing your views and be influenced by them. So I think eventually the pendulum will swing the other way on that issue.
You made a comment earlier today I thought was really quite interesting. I wish you'd share it with the crowd, but what Marty, your husband Marty, said was the symbol of the country. This is interesting.
And he said, the true symbol of the United States is not the bald eagle, it is the pendulum. When things swing too far in one direction, it will start to come back.
Wise words from Marty. Comment from this side.
Hey, I was a little close. A little more, sorry about that. Something I've wondered for years. Why does Justice Thomas not ask any questions? Ever?
Did you hear the question?
Yes, I heard. Well, let me compare what it was like in the 70s when I was arguing before the court. I was able to get out sometime a whole paragraph before there was a question. Nowadays, a lawyer will be lucky if she can get out 2 sentences before the questions. So one reason Justice Thomas doesn't ask any questions is he thinks the rest of us ask far too many questions, and he wants to give the advocates a fair chance to present their case.
Yeah, so you said that Justice Sotomayor got the record for most questions the term before last, but you didn't say,
No.
Did Justice Scalia regain the honor?
Yes, he did.
Yeah, okay.
He regained the honor, and Sonia was in 3rd place, because Justice Breyer came in 2nd.
Okay, question on this side.
Justice Ginsburg, thank you so much
Oh, I
for
like
being
your
here.
T-shirt.
Oh, yeah, I thought that you might, so I wore it today just for this. So this is the notorious RBG T-shirt. So my question for you is, I just read I believe it was in the New York Times, an article analyzing how the justices cite to amicus briefs and how sometimes the amicus briefs themselves are lacking in citations, or maybe some of the factual findings or studies are questionable. And so I'm just wondering, what is your personal philosophy on what makes a persuasive amicus brief, and when you choose to cite to amicus briefs in your decisions?
The court in the most watched cases gets dozens of amicus briefs. Most of them are what I call Me Too briefs. So my law clerks have the job of reading all the friend of the court briefs. I read always all of the briefs for the parties, but they will sort the amici briefs into 3 piles, and one pile is skip. Another is, there's an interesting argument on pages 10 to 16 of this brief. And then the smallest pile is read, because it says something different than what's in the parties' briefs. I wish there was some way we could get our friends to come together on one brief instead of writing the same thing over and over. But sometimes an amicus brief can be tremendously influential. And I think of the one that was filed by the top brass of the armed forces.
Is that in Grutter?
Yes, in the Michigan affirmative action case. And what they said was, we had a huge embarrassment when our forces were all the enlisted members that African Americans were overrepresented among enlisted members, but rarely seen in the officer corps. We cannot go back to that kind of military. We have to have African Americans in leadership posts. And that's what all the military academies are doing, and they're doing it successfully. And it would be devastating to take away from them the ability to have an affirmative action program. That brief was very influential.
We've come to the time we were going to adjourn. There's quite a few people lined up, but let me just take a question from this side, a question from the other side, and then, young man, did you have a question you were going to ask also? Maybe that would be a nice one to finish with you then as well. So,
sorry. Okay.
Or are you going to, you go ahead and ask your question. We'll call on him next.
Thank you, Your Honor. I have a question relating to the Hobby Lobby decision. What do you think about the developments after the contraception decision? Several religiously affiliated schools and organizations said that on similar sincerely held religious beliefs, they weren't going to hire or educate or promote gay people. What do you think about that?
This was an employer who said, I will have no gay people in my workforce. Yeah. I can tell you that that is a question that is likely to come before the court sooner or later. Maybe Congress will be ahead of us and will enact an explicit ban on discrimination based on sexual orientation. Maybe not. And if it comes to the court, and the court has to make the decision under the Equal Protection Clause, I can't tell you how I think it would be resolved. There's a well-known Ginsburg rule that I set when I was before the Senate Judiciary Committee for the hearing on my nomination. And it was, you can ask me about anything that I have written, any opinion, my 13 years on the DC Circuit, any article I wrote as a law teacher, but you can't ask me a question that will signal how I would decide a case that very well may come before the court. So that's the only answer I can give you.
I think that's the minefield you were warning people about. Let's take one last question on this side, and then we'll have one more on the other side.
Great, thank you. First, just as president of the Women's Law Student Association, I just want to say thank you again, and we're so happy you're here. As a pioneer woman in the legal industry, what is a piece of advice you have for us females in the room just at the beginning of our careers?
What is the advice I would have for today's women law students? Be as fired up as the students I had in the 70s. You know, in the 70s, the women in law school were in women's law associations, trying very hard to propel this social change that was going on in society. In the 80s and 90s, well, that interest seemed to recede. And frankly, I think some young women thought, it's not my problem. I can do anything I want. And they forgot about poor women who aren't able to do anything they want. And if I could give you, as a startling example, restrictions on abortion. There will not be a time in the United States again when a woman of means does not have access to a safe abortion. There are some states that will never go back to the way it was. There were, after all, 4 states at the time of Roe v. Wade that allowed abortion in the first trimester, if that's what the woman wanted. So today, take a worst case, say Roe v. Wade is overruled. Any woman who has the money to buy a plane ticket or bus ticket, not her problem. She'll be taken care of. It's the women who don't have that wherewithal who will suffer. So, but I'm beginning to see signs of women waking up. Maybe decisions like Hobby Lobby are some help in that regard, and arguing as ardently as the young women did in the 70s. There's a problem that women today face that they, in the 70s it was the closed door era. Women couldn't do this, they couldn't be police officers, couldn't be firefighters, couldn't work at night, all kinds of restrictions. So those are gone. But what exists is a more subtle form of discrimination. I call it unconscious discrimination. And my best example is the symphony orchestra. When I was growing up, you never saw a woman in a symphony orchestra except playing the harp. Someone had a brilliant idea. Let's drop a curtain so the auditioners don't know who is playing. Well, overnight, women got jobs in symphony orchestras, and people who were so sure they knew the difference between a woman playing and a man got it all wrong and confessed error. Even Howard Taubman, who was the New York Times music critic, he said, "You can blindfold me and I'll know if it's a woman at that piano or a man." Well, he was all mixed up. But it's that idea of unconscious bias that women have to get past. And the more women that are out there doing things, the better off all of us will be.
We have a question on this side from a young man. What is your question?
Hello, Justice Ginsburg. So I've been very interested in your work on the court, and I was really wondering what you thought would define, what issues would define the court going into the future, and really how they would affect their decisions from now on.
I think he wants to know what issues will be the issues of the future when he becomes a lawyer.
Oh. One issue that will certainly be on the table. Well, how old are you now?
12.
12.
The environment will be a very big issue. And we are learning more and more about the damage that we are doing to the planet on which we live. There has been some reluctance on the part of our legislatures to do anything about it. But that will be, saving our planet will be a major issue for your time. Technology will be an important issue. We just decided this term a case involving a man who was arrested lawfully. The police took his cell phone and they looked through it and found evidence that he'd been doing bad things. And the rule had always been that anything an arrested person carries on his person in his pocket, say a wallet or a diary, the police can seize and inspect. But cell phones is a whole new thing. It's not like a wallet or a diary. You can have on that cell phone more than you could pack into any file cabinet. So the court dealt with that new technology and said that the police cannot, without a warrant, inspect your cell phone. And we will continue to get questions as technology develops. And discrimination cases will still be with us. I'd like to say I could see a future where it would be entirely over. But I think we have a way to go in that area as well. Anyway, I think the law is a tremendously fulfilling profession, and I'm glad to know that you aspire to be a lawyer.
What a wonderful note to end on. Talking about the future, please join me in thanking Justice Ginsburg. There is a reception in the law building. I'll ask Dean Whitman just to tell people how to get there. Oh, here you
Just go outside. There'll be some people who will point you over to the law school. It's in the Robbins Kaplan Miller and Cerisi concourse.
They'll find it. Okay.